Hello everyone, today we are going to understand how to answer BNS questions in law school exams. So BNS is replacement of IPC. This PPT will cover answer to plain questions as well as answer to applied questions. So let's see. Firstly, what are the factors on which answer to the question is based, or what are the determining factors for our answer? Firstly, the marks allotted. Secondly, whether the question is plain or application based. And thirdly, how much time you have to answer. That is the rule. So firstly, answer to a plain question. A plain question can be like explain the essentials of accident as a defense, define abatement, distinguish between abatement by conspiracy and criminal conspiracy under section 61. Now, what can be an example of an applied question? This is an example. This is an illustration of defense of accident itself, given in the Bare Act of BNS. A is at work with a hatchet. The head flies off and kills a man who is standing nearby. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Now, let us see the structure one by one for both type of questions. Firstly, for a plain question. Now, firstly, the person writing the answer must discuss the purpose, why there is this provision in the law. So we will say that Section 18 of BNS exempts the doer of an innocent or lawful act done in an innocent and lawful manner from any unforeseen result that may ensue from accident or misfortune. So basically, an innocent person who accidentally causes some harm to someone else is exempted by this provision. Now, this is the purpose. The next part which must be there in the section is the provision itself. Briefly discuss what is the provision. So briefly discuss section 18 here. Then you must discuss any maxim related to the section. And it is not mandatory that every section will have a maxim. So if there is, then you can discuss. If there is no one, then you can skip it. But in some cases, there can be latent terms. For example, for accident, there. So let us see how we are going to discuss these four essentials. Now, the essentials of accident and lawful act in lawful manner, since they are of lesser importance and require lesser explanation, the other two, the absence of criminal intention or knowledge, and the proper care and caution, they will be explained in more detail. Now, by more detail, we need, I mean to say that we need to add cases when we are going to explain these provisions. So when we are discussing absence of criminal intention, we need to discuss cases such as this is a leading case, State of Orissa versus Ghoradas. Now, the facts have been written of this case, plus the quotation of the High Court has been written. However, it is very difficult when we are going to write it in the exam to just reproduce the same quotation. So what we can do is to just write the facts and then we can just straight away explain the observation in our words. There is no requirement of just quoting. And one thing is important that you are obviously you are not going to just reproduce what the High Court said. You will use your own words. So do not use the quotation marks because it will give a false impression that that you are trying to mislead the examiner that you are quoting the quote. Whereas you are actually just writing what you understood about the observation of the quote. So do not use the quotation marks. You can just write in this way. You can first write the facts, and from this line, you can write High Court, and then you can write and observe that. So, like this. Since it is an important essential, you need to discuss other cases such as State of Madhya Pradesh versus Rangaswamy. And then there is this other essential, that is proper care and caution. So this also needs to be explained by a case law. So again, there is this case which can be written to explain this essential. Now this part is very interesting, and very only a very limited number of students will try to write this. This includes two things in the end after you have explained the essentials. That is, what will happen if there is absence of any of the essentials. So you can write that if any of the essential is absent, the accused cannot get the defense of accident, like in the present question. And then lastly, you can just give a conclusion. And if there is any amendment required in the provision, obviously not every section will require amendment. But if there is any provision which requires amendment, then you can write that so and so amendment is required. For knowing where amendments are required in the criminal law or in the BNS, you can refer to the Pillai's book, where after each chapter they have written prospective or amendments they want to introduce in the law. So Pillai has given very good recommendations after each chapter. So that can be a source of understanding the proposals for amendment. Now let us understand the structure for an applied question. So this is an applied question, which uh, which is actually an illustration of section 18 of the BNS. Now this is written that the question is that A is at work with a hatchet. The head flies off and kills a man who is standing by A. A was a skilled worker. Does A commit any offense? Justify with relevant provisions and cases. Now, first of all, this is a very small application-based question, not a very detailed one. So there is only the issue of whether he will get the defense of accident or not. Now, for answering an applied questions, what we have to write in the answer? First of all, the starting of the answer will be like the plain question only. You will write the relevant provision, you will write the origin of the term, the Latin term, and then you will write the essentials. So that part will remain same. What differs is that after you have written all those basic things, you are going to now write about the relevant facts, and you have to relate those relevant facts. Now, this is how we are going to relate the facts. Now, first of all, you must break down the facts and just create issues out of, or the charges or the main issues out of the facts. So these are the issues that can be created. Whether A was doing a lawful act, was A doing the lawful act in lawful manner, was A using lawful means, and whether A was exercising proper care and caution. Now, if the facts have been detailed, you could have answered them one by one. But since this is a very question having very limited amount of facts, so you can just straight away give answers to all the issues, combining. No need to just give details of each and every issue. But the framing, the fact that you framed such issues will always give the examiner an impression that you understood the facts correctly and you are able to analyze the facts in light of the applicable law. So try to create facts, try to create issues and relevant issues out of the facts. So the answer to this facts will be, in the present case, A was at work, and assuming that his work required him to use a hatchet, then he was doing a lawful act. Some professions are inherently dangerous, but that does not make them illegal. Next, he was skilled at his work, so he must be working with proper care and caution. It shows that he was doing the act in a lawful manner, with lawful means, and with proper care and caution. Now, lastly, you will give your decision. Obviously, this is an applied question, and you have to give decision in one side. And you can give decision on either side, but you must justify it with logic and provisions. So the decision in this case will be an accused is entitled to the defense of accident under section 18 if all the above four essentials are fulfilled. In the present case, A fulfills all of them, so he is entitled to the defense of accident and he is not liable for any of it. So that this will be the decision and the last part of the question. So here we are not going to write conclusion or way forward because this is an applied question and this is the end of the question. Now, briefly, we can summarize and we can say that this is the structure for a plain question, this for an applied question. So, for a plain question, we start with the purpose or object, we write the relevant provisions, then we write the maxims, then we write the essentials plus the leading cases, and we write them corresponding in each every. In you will write the first essential, its cases, then the second essential. Then we will write the effect if any of the essential is absent, and lastly conclusion or way forward. For an applied question, you will start with the purpose and object, same as plain question, then the relevant provision, then the maxims, then the essential and leading cases, then the brief facts, and then application of the fact, and lastly, decision. So this was all for writing answers to a criminal law question. Thank you.